Hey everyone, this is Mark McClune with Retail Investment Group. I'm joined by Stephen Davis and John Tobin, and today we had the opportunity to speak with Mike Tippett, a real estate attorney that we have done quite a bit of business with over the years. A few main points that we go over are what to do if you receive a rent abatement letter from your tenant, what is force majeure and how does it come into effect, and how to navigate the next few months as a landlord. If you have any specific questions or comments, please feel free to reach out. Hope you enjoy the call and stay safe.
All right, I'm Mike Tippett with the Atlanta office of Carlton Fields. I've been practicing commercial real estate law for about 25 years now, really doing all kinds of transactions, buy, sell, finance, lease, work out, foreclose, kind of the whole thing. And I've developed a niche practice over the last few years in single tenant net lease properties, and I've had the pleasure of working with Stephen and his team on quite a few of those.
Perfect. So one of the main questions that we're seeing these days, because we deal with a lot of triple nets and a lot of individual investors, they're getting letters from their tenants, these landlords that are absentee. They live on one side of the country and the properties are elsewhere, whether they're Burger Kings or Wendy's or daycare, or all these businesses that have been affected. What's the first thing they should do or not do when they receive one of these letters from their tenant?
Yeah, well, our landlord clients started getting these letters about probably 10 days ago. So we've seen quite a few of them. They all kind of look the same. But I think what you should do when you get one, and what it's going to do probably is say, COVID equals force majeure, therefore I need help.
Right.
Without being very, very specific about what they're looking for. So I think the advice we're giving is to, first of all, acknowledge the circumstances. If they talk about force majeure or any of these other sort of arcane legal theories on which they believe they are entitled to rent relief or even a termination of the lease, we recommend don't acknowledge those, don't indicate at all that you accept those theories, but simply say, if you're looking for some help, tell me specifically what you're looking for. Okay, and you should also treat it like a lender is going to treat you, the landlord, as a borrower. You're going to probably have to, if you go to seek debt service relief, present some financial information. So I'd ask that from the tenant too. Tell me what your sales have been recently. Tell me, what your operating expenses are, what your cash balance is. Kind of paint the picture. Show me why this particular location needs relief. And then the other thing you should do is in a responsive letter, make sure you include what we call non-waiver and reservation of rights language, which basically says, if there's a default and we don't exercise or delay in exercising our remedies, we're not waiving them. In fact, we're reserving them. And then I think the other thing to keep in mind if you're responding to one of these letters is kind of know what your end game is. Right now, lenders are pretty freely granting 2 to 3 months of debt service deferral. So anything that a landlord agrees to with its tenant should be short term. And the biggest thing probably is make sure it's properly documented.
Now, you just brought up a topic with regards to mortgage relief for those landlords for 2 to 3 months. What should a landlord do in that case? Like, how do they initiate that? Do they contact the lender? Is it just,
yes,
it can't just be assumed you don't have to pay your rent for the next month or two?
No, in terms of interfacing with the lender, you absolutely have to, take an affirmative step to contact them. You want to let them know what the situation is, establish some communication with them, and make a specific ask. Tell them what's going on. You got to be transparent. If you do all that stuff, then you're going to find that you're going to get some help from your lender under the current environment. This is not like prior downturns where it was really difficult to get any kind of relief. All the lenders that we're talking to are taking a very practical, short-term approach. Everybody's in this together. This is different than any other downturn we've seen. So the other thing is, if you can make your next mortgage payment, go ahead and make it. Get yourself on the good guy list. But if you can't, tell the lender why you're not making it, that you've got, some cash, but you're using it for operating expenses, and be prepared to give them current financial information, whether that's OPEX and budgets, cash balances, all that sort of thing.
So you're saying that if you have a mortgage on a fast food restaurant, that in order to get some relief, you should be expected to provide the lender with your cash flow as a household, as an individual?
Well, they want to know what the guarantors, how solid the guarantor is.
We hear lately a lot with regards to force majeure, where these tenants, I mean, is that what they're really doing? Is they practicing force majeure? Is that the right way to put it? If they're saying they can't pay, or are they just simply using the COVID-19 as really the reason behind it? Are they?
Yeah, a force majeure provision is a provision, as you know, that's in basically every lease and always has been. It's a provision that is broadly intended to excuse parties from performing where circumstances that are beyond their control prevent them from doing so. They're always very ambiguously drafted. They talk about acts of God and circumstances beyond our control, unless they specifically talk about things like epidemics and pandemics and quarantines. It's unlikely that those provisions would be interpreted to apply to excuse a tenant from not paying rent. To the extent that they apply, they generally apply to non-monetary obligations only, and most leases will say that. So, for example, they might excuse a tenant from breaching an operating covenant, but it's unlikely to excuse them from not paying rent. But tenants right now are panicked, and that's really the only thing, or one of the few things they can think of to kind of throw out there. But from the tenant standpoint, that's really not a strong argument, and I wouldn't accept that as a basis for giving them any rent relief. I think any deal you work out with your tenants is going to have to be sort of outside of that concept.
Makes sense.
Hey, Mike, I've got a question. This is Mark.
Yeah.
What would be your absolute first piece of advice to a landlord if they do inevitably get a letter like this from their tenant?
I think the first piece of advice would be, first of all, you should be expecting one. Second of all, you should already have a responsive letter kind of ready to go out. Even in anticipation of getting such a letter, I would probably go ahead and reach out to your lender if you have one and say, look, we all know what's going on out there. I've got a tenant that's in XYZ business. I'm expecting they're suffering, and I'm going to be coming to you for some discussion about how to work things out over the short term with my loan.
Okay. And as far as, the first thing to do, what would you say is the absolute worst thing somebody could do right now if they get that letter?
The worst thing I think they could do is just sort of accept whatever argument the tenant is making about COVID being an event of force majeure or an excuse to not pay rent or to terminate their lease. I think you have to go back with a sort of counter argument saying, we appreciate the hardship you're facing, but we're willing to work with you, but we need for you to ask us specifically what it is you're after, and we'll see what we can do. And the other thing is, to the extent that a landlord reaches a deal with a tenant, remember that if you have a loan, under your loan documents, there are very likely covenants that prevent you from doing any sort of agreement like that without getting the lender's consent. So that's why you want to get front and center with the lender early on.
Sure. I mean, that makes sense. And that you brought up something where a lot of people probably wouldn't really think about, that the lender should be involved in those discussions. It should not be just a topic between the landlord and the tenant themselves. Definitely get the lender in the loop.
Right.
Probably makes sense for the lender to receive that letter as well, so they can see it firsthand.
Yeah, if the letter's already come in, I would probably include that in the package to the lender, or the letter to the lender, kind of setting up a discussion.
Mike, this is John Tobin.
Good, John.
What are your recommendations for landlords and just overall how to navigate themselves over the next month or so, next 2-3 months?
Well, it's really sort of other than kind of reacting to what's coming at you from the tenants and managing things on the lender side. I think you just sort of have to batten down the hatches and be prepared for the fact that whatever's worked out with your tenants and your lenders now is probably not going to be the last thing you have to do. And, this is probably a short-term fix. As we saw the CARES Act that's been passed today, it's not expected to be the last injection of capital into the market. So I don't think this is going to be the last chapter in terms of the discussions with the tenants and the lenders. So I think you just sort of have to be prepared to kind of hunker down and be proactive in working out whatever you can with your tenants and lenders, and just know that even though it's going to take a couple of steps to get there, the nature of this downturn, I think, is such that we're going to come out of it, probably towards the end of this year.
Business interruption insurance, Mike, we've heard that come up, and that's not an area that a lot of landlords know to ask or bring up, or if this qualifies as a topic for tenants to look to business interruption insurance in their policy. What's a good practice to approach that subject if someone?
Yeah, I think what we're hearing from the insurance folks is that you've got to look at each policy on a sort of an ad hoc basis. Business interruption policies generally are not going to cover something like this. In fact, most of them have a specific exclusion for pandemics, believe it or not. And business interruption insurance generally covers situations where there's actual physical damage to the property. That's really what they're intended to do. So that's another unfortunate piece of news in this whole scenario, is that tenants aren't going to be able to draw on those insurance policies to make the rent payments. And if landlords have rent loss insurance, those are also likely going to exclude losses coming about as a result of COVID. Now, there may be a few policies out there that were really well crafted that may pick up these kind of losses, but from what I'm hearing, that's pretty unlikely. It's kind of like force majeure. It's a general principle. It's just not going to apply.
We have a couple of transactions, Mike, that are currently pending. I'm sure those are unfortunately ripe for renegotiation. Do you have any advice or guidance to clients that are involved in a transaction? They're in a 1031. This letter probably got floated out, and here it is. Everyone's kind of in this pickle together.
Yeah, the 1031 thing is a real issue because if you're trying to close a transaction and you can't get it closed because of where we are right now, you're still going to be up against the same time clock. So that's a problem. In terms of retrading, I think we're going to have to wait and see how that plays out. Force majeure doesn't apply to PSAs. So there's really no basis other than the parties kind of getting together and agreeing on some restructure. And if a buyer has hard earnest money, they don't have much leverage. So that's really going to be interesting to see how all that plays out. But I think that's just a pure negotiation.
We probably just have a couple more questions, or this one that still is, since we deal with a lot of 1031 questions, 1031 clients, do you think that the IRS, they changed the tax due date from April 15th? Do you think they'll change the timing requirements for 1031s?
Yeah, I think that they very well may, and I think that may be part of sort of the second wave of the legislation. I don't think that's not part of CARES as far as I know, but That may be coming, but I think it's going to be a little ways off. For anybody that's in a 1031 right now, probably not going to help them, but it'll help on down the road.
Mike, I'm just wondering, I've got a deal, the buyer's needing to get some financing. Is there any advice you have or anything we could provide to the lender specifically that you think would help at this time?
This would be a buyer looking to buy a single tenant property.
We're in escrow, and right now they're just working on getting the financing approved, and we're trying to provide anything we can additionally.
Yeah, to show that the income from the tenant is going to be solid. I think it's going to depend on the tenant. If it's a chain tenant, that's got some strong financial backing, you can point to that. If it's a single tenant property or a non-chain kind of operator, I think you're going to have to dig down and get some information from the tenant, and I think that's what you're going to have to provide. I don't think there's anything else that you can do other than kind of mine what that tenant is able to provide to you to show the lender that the income's solid.
Yeah, good material.
Mike, thank you so much for your time meeting with us today. We really appreciate it. All three of us, as well as Retail Investment Group and all of our clients. We know how valuable your time is, and especially right now with all the uncertainty, you've got a lot going on, but definitely appreciate it. And we will always continue to refer you.
Glad to do it. Thanks, I appreciate it.